Hello, this is Matt on the Moon Lambo channel. The SEC v. Ripple case is a loser for the SEC. And the more time passes, the more things unfold, the more crystal clear it gets, and the SEC must realize that the prospects of this turning out well for them, looking a bit more slim. And fine, we don't have all the facts. Not everything is public to this point, so I, as well as you, we all reserve the right to change our perspective. But man, if you just look at the way things have been tilting in all the pre-trial happenings, it's extremely lopsided in favor of Ripple and against the SEC. And then if you just look in terms of, case law, legal precedent, couldn't be more clear that the SEC is on the wrong side of history. They're also a bunch of disingenuous liars. They're complete and utter asshats working at an asshattery. And everybody can see this. In fact, every lawyer, with rare exception, that has ever publicly spoken about this case has stated that the SEC is on the wrong side of this. And so take a look at this headline from Forbes, and this is the latest from Rosalind Layton, a senior contributor with Forbes. Crypto law experts suggest SEC likely to lose key case and discredit Howey test. Now, I love everything that Rosalind Layton has written on the topic of the SEC v. Ripple case, and this latest piece is certainly no exception, sharing perspective from well-known attorneys within the XRP community, specifically attorney Jeremy Hogan, as well as attorney John Deaton, just shreds the SEC perspective. So I'm going to run through this, but before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. As the cryptocurrency trial of the century draws to a close in a Manhattan federal court, there are increasing signs that the U.S. Securities and Exchange Commission faces a bruising defeat against the San Francisco-based enterprise blockchain innovator Ripple Labs. The verdict could drastically limit the SEC's authority to regulate crypto in the United States. And if that's how it ends, it will have been a self-inflicted disaster from the start. The SEC filed its bombshell lawsuit against Ripple and its two senior executives in December 2020, on the last day in office for ex-chairman Jay Clayton. The Republican voted with the two Democrat commissioners to allege that the cryptocurrency XRP is an unregistered security because its only utility since 2013 has been to be an investment contract in a company that uses it for its payment software. The breadth of the allegations was sweeping as the lawsuit's legal theory overreached. Almost 2 years later, the SEC faces a painful reckoning because Ripple decided to fight back, as did tens of thousands of retail users of XRP who have no connection to Ripple other than being co-victims of the government's behavior. Exactly. So I'll just pause here to think about this. And of course, the SEC, I've said this many times before, but it's worth repeating here because it could not be more obvious. The SEC, I mean, they're out over their skis. Like they never anticipated that there would be literally tens of thousands of XRP holders that would seek to speak out in the SEC Ripple case against the SEC. There is no precedent for this in history for this type of behavior. The people that allegedly the SEC is protecting, coming back and saying, no, if this is protection, I ain't want none of it. Because that's exactly what's happening at this point. And my gosh, the idea of even secondary sales of XRP on secondary markets, those are securities. So if and I'm not granting this, but let's say that early sales of XRP were somehow a part of some sort of investment contract, so it's an unregistered security, those specific sales, say maybe in early days, even if that were true, does that then mean that all sales for the rest of the time, even on secondary markets, people have nothing to do with Ripple, that somehow there's some sort of logical connection that make it reasonable to state that all sales for the rest of time are somehow also, under that same scheme? They're also part of that investment contract scheme? Well, of course, that's completely absurd. Anybody who's being intellectually honest would realize that. And so that's why anybody that comes in as a blank slate and just learns the facts, just about 100% of humans are going to come to the same conclusion. This is tremendous government overreach, and it's repulsive. Piece continues. The SEC realized early in the litigation that they'd gotten lost in a maze of its own making. The Stellar Events team for Ripple went for the jugular, calling out the bizarre SEC premise that XRP had been an unregistered investment contract in Ripple since 2013, and that even sales of billions of XRP tokens on the secondary market for 7 years were securities as well. Ripple didn't need to look too hard to document how the SEC had repeatedly waffled before market participants for years over whether XRP was a security. Yet, it now alleged that Ripple and everyone else in the market should have known anyway. Ripple also focused on a market-moving speech in 2018 by Clayton's director of corporation finance, William Hinman, who laid out a vision of how XRP's chief market rival in the crypto markets, Ethereum's native cryptocurrency Ether, was not a security because its ledger had decentralized over time. The internal SEC emails and drafts behind that speech became central to Ripple's rebuttal, and the SEC spent 18 months fighting 6 separate bench orders to turn them over, making it increasingly clear that their real behind-the-scenes confusion around tokens would be humiliating if it ever went public. Yeah, and so let's pause. It's amazing that they actually handed those documents over to Ripple. They're still not public, and they still might not ever be. In fact, don't forget that even Attorney Hogan stated that if settlement's going to happen, it's most likely to happen by November 15th. And so that would mean within the next couple weeks. So the fact that, yeah, they abide by the court order and they handed that over doesn't mean that that stuff's ever going to see the light of day. It's also possible, at least one attorney within the XRP community pointed out, that, perhaps as part of a settlement deal, there would be terms that would make it illegal for Ripple to hand over those documents, because they would be humiliated, would they not? I mean, based on what we've seen from Ripple's general counsel, so that's their top in-house legal guy, Stuart Alderati, as well as Ripple CEO Brad Garlinghouse. He said that it will shock people once what is in those emails gets out into the public. And I believe it. I sure, because otherwise, why would they have been fighting so hard and for so long? Peace continues. Ripple finally got the Hinman speech documents last month. CEO and co-defendant Brad Garlinghouse tweeted that the SEC wants you to think that it cares about disclosure, transparency, and clarity. Don't believe them. When the truth eventually comes out, the shamefulness of their behavior here will shock you. And that was a direct quote from Ripple CEO Brad Garlinghouse. Now that the parties have reached the end of an exhaustive discovery phase with dueling motions for summary judgment, Ripple fired off a robust set of arguments, while the SEC's motion was just a warmed-over version of its original complaint. Some legal observers noted that the agency failed to prove its case. Its own expert said XRP's market value was not tied to Ripple's performance, and it didn't find any way after 2 years to demonstrate on how tens of thousands of retail users and traders of XRP knew that the token was an investment in a company that most of them had never heard of. And so I'll just pause to state here, I'm not sure which expert Rosalind Layton is referencing this piece. If any of you know, please drop a comment below. I would be very curious. I was even looking up before, because I knew that they had their expert witness, Dr. Albert Metz. He's the one that made the 100-plus page report, getting paid, I think, somewhere in the neighborhood like $600 an hour to make this damn thing. And he argued that, but not for Ripple, the price of XRP wouldn't have gone above 2 cents, I believe, is basically what he argued, which is completely absurd, because for that to be true, that would mean that XRP would have been the only cryptocurrency in the entire damn planet that during the mega altcoin run of 2017 would not have gone higher. So, if and I'll take Rosalind at her word, she's saying that there was an expert, an SEC expert witness that came to the conclusion, that XRP's market value is not tied to Ripple's performance. I'm just very curious as to which one that is, because the only expert witness I was aware of said the exact opposite, that it was tied together, and typed up a, like I said, 100-plus page report, failing to argue that case. And then, of course, Ripple, and this goes back at least a year ago, but then Ripple had their own expert witnesses comb through that report, and they rebutted it and said that they're using, I can't remember the exact verbiage, but it was something along the lines of some sort of false method for calculation of how he came to conclusions, all that stuff. Anyway, peace continues. This is where the case really went south for the government. Retail XRP holders launched themselves into the case by the tens of thousands. Led by Rhode Island attorney John Deaton, they first attempted to intervene against the SEC by asking the judge to make them defendants along with Ripple. The SEC, plus think about, if I could just say this too, you do realize that means literally what was asked is, we want the SEC to sue us too. That is what that means. That's awesome. Like, no, this is highly consequential for us. Yes, we gotta get in this. Sue us too. Anyway, Peace continues. The SEC responded with a ferocious attempt to malign Deaton personally and portray his clients as unworthy cranks. Instead of turning her nose up at the XRP holders without comment, Judge Annalisa Torres denied their motion to intervene by saying she'd spent time digging into legal precedent to see whether it was even possible for a third party to make itself a defendant in a case, and came up empty. But she offered them the chance to file amicus briefs instead, sending a blunt signal to the SEC that real investors were going to have her ear when its presumptions of their motivations would be pondered. In retrospect, with all that has happened since, anyone with a political instinct close to Gensler should have convinced him to fold then and there. Deaton's putative class of XRP holders has swelled to more than 75,000, that's right, 75,000 XRP holders represented here, among whom more than 3,000 provided affidavits to Ripple's defense team stating that they had never heard of the company they were allegedly investing in before the SEC filed the lawsuit. Those affidavits were entered as evidence with Ripple's motion for summary judgment, which was a brutal takedown of a federal agency at odds with its own mission to protect retail investors, appealing to authority granted in the 1946 Howey decision from the Supreme Court to argue that anonymous lines of computer code are investment contracts in a company. Now, when you word it like that, it illustrates exactly how silly the whole point is. You know, think about this. Anonymous lines of computer code are now investment contracts in a specific company. Nope. Peace continues. Behind Deaton were other XRP users with no connection to Ripple, who have filed amicus briefs, as well as the two most prominent crypto industry associations, the Digital Chamber of Commerce and the Blockchain Association. The SEC has had no allies, not even its own expert witnesses who ended up giving ammunition to the defense. Attorney Jeremy Hogan, who has filed the case on his popular YouTube channel, says the SEC can only prevail with its summary judgment motion if Judge Torres, quote, forgets her first year of law school, end quote. I love that line. I remember hearing that in that video. I was just like, oh yeah, that is fire. So if you forget everything about law, then okay, yeah, I guess that the SEC has a compelling case. I love that line. Only if she forgets her first year, the entire first year of law school, maybe you can trick her then, right? Peace continues. Prominent legal experts like Kurt Levy, or maybe it's Levy, I'm not sure to say, of the Federalist Society and Professor J.W. Verrett of George Mason University's Scalia School of Law agree that Ripple is on track to win this case. Worse for the SEC, Verrett predicts that if the SEC appeals up to the Supreme Court, it is likely to not only lose, but set a sweeping precedent that would limit or eliminate entirely the application of Howey on cryptocurrencies, which defy the definitions of 1946. So why is Gensler still letting his enforcement division drive the bus off a cliff? I love this. They are litigators, but Gensler is ultimately a political figure. Politicians, Deaton said recently in an interview, are all about turning a loss somehow into a win and moving on. Ripple's general counsel, Stuart Alderati, has made it clear that they will settle, quote, in minutes, end quote, and pay a fine if the SEC will make it clear that today's XRP is not a security. Having expended his political capital, Gensler should take the deal. Golf clap for Rosalind Layton, everybody. That is fantastic. And my gosh, I'm telling you this, I would not want to be in the SEC's position. I do not envy the position that they're in. Now, as far as the idea of this thing making it to the Supreme Court, it's not impossible, but I don't think that's probable. Because would the SEC really choose a path that would allow it to get there? Because they can prevent all of this. And I think that they must understand at this point that they don't have the winning hand. So even if it did go that far, my gosh, they're just sabotaging themselves at that point. I just don't suppose it's ever going to make it quite that far. And not that I would want it to anyway, because, I mean, what would that mean? Like, XRP would just be in limbo for how many years then? Because I remember when this thing broke, if you're talking about, so fine, the case was filed into 2020, but I remember seeing Attorney John Deaton in the first part of 2021. I think he was an interview on The Chain. He said, now look, if this thing actually did go to the Supreme Court, I'm pulling from memory here, but I think he said that it would be from that point in time, another 5 to 7 years. So, I mean, it could happen. I find it hard to believe that the SEC would allow it to get to that point. And I still think that it's very possible we're going to see a settlement. Maybe we don't. Maybe this thing's fully adjudicated and the SEC ends up losing, in which case, they're going to appeal. But is what it is. If they're going to be that stubborn, this just isn't going to turn out well for them. Everybody that's not an attorney within the SEC, if they're attorney but not in the SEC, with rare exception, they all see it. The writing's on the wall here. This is not looking good for the SEC. I'm not a financial advisor. You should not buy or sell anything because if anything I say are right, that would be a very, very, very bad idea. Until next time, to the moon, Lambo.